Good afternoon and welcome to the penultimate session of the Massey City Summit. Our topic for this afternoon is Constitutions and the City, Canada in a Comparative Perspective with our keynote speaker, Ran Hirschl. My name is Enid and I'm the director of the Institute on Municipal Finance and Governance at the Munk School of Global Affairs and Public Policy at the University of Toronto. Before we begin, I would like to acknowledge the land on which the University of Toronto operates. For thousands of years, it has been the traditional land of the Huron-Wendat, the Seneca, and most recently, the Mississaugas of the Credit River. Today, this meeting place is still the home to many Indigenous people from across Turtle Island, and we are grateful to have the opportunity to work on this land. We've talked a lot at this conference about the lack of powers and resources of Canadian cities. And we've talked about different ways of changing that situation through constitutional reform and through other means. Indeed, earlier this afternoon, we had a panel on cities and constitutional change, and we got into the nitty-gritty of the Constitution, general amendments, amendments under Section 43 and 45, provincial constitutions, manner and form provisions, very much in the Canadian context. The presentation now is also going to talk about constitutional reform. What does constitutional status look like, and what does it mean for cities? But to answer this question, we're going to move away from Canada and look at other countries where cities have constitutional status. Our guest speaker will explore how cities are recognized in the constitutions in different parts of the world, including places like South Africa, Brazil, India, Mexico, China, and the European Union. And he'll talk about what it means for how cities function in these countries. So I have a really easy job today compared to what I did yesterday when I had a whole panel. All I have to do is introduce Ran, engage in a brief discussion with him, and then turn it over to you, the audience, to ask him questions. And as you know, you can use the chat function at any time and put your questions in there, and I will ask them to Ran later. So I'm going to introduce Ran, but his bio is going to be in the chat. It's also on the Massey website, so I'm not going to spend a lot of time except to say that he is Professor of Political Science and Law at the Faculty of Law at the University of Toronto. He holds the Alexander von Humboldt Professorship in Comparative Constitutionalism at the University of Göttingen and heads up the Max Planck Fellow Group in Comparative Constitutionalism. Ran is the author of a new book, and I don't have a slide, but I do have the book, so I want to show you that I've bought it. It's called City, State, Constitutionalism and the Megacity, published by Oxford University Press in 2020. He's also published an IMFG paper on cities in national constitutions, northern stagnation, southern innovation, and I will put links to both of those in the chat in a moment. But for now, over to you, Ran.
Thank you very much, Enid, for this generous introduction. And of course, thanks to the conference organizers. Just bear with me as I share my screen here. And I hope you can all see. Is that okay? Yes? Should I take it as a yes?
That's a yes.
Okay, wonderful. So thanks again. And there's always those 30 seconds of awkwardness when we share a screen. Thanks to the conference organizers. Thank you, Enid. We've had a terrific conference so far, 2.5 days. I learned a lot. What I want to do in the next 25, 30 minutes is to, as Enid suggested, to put the intricate debate in the Canadian context, perhaps in a broader comparative perspective, so that we can understand perhaps better what are the options and repertoire of options for constitutional renewal out there. So as Enid suggested, the talk will be based on one theme I explored in a recently published book of mine, City State, by Oxford University Press, published in summer 2020. And Enid will put the link to the book and a couple of other papers in the chat. All right, so let's roll. And, you know, as many of us know, certainly having spent the last 2.5 days in this conference, cities in Canada are in a tough position and are often viewed as creatures of the provinces. There's a long string of rulings by Canadian courts suggesting that cities are very much either powerless or near powerless. And of course, from a broader perspective, the combination of a 19th century binary federal provincial spatial governance regime and a very rigid, one of the most rigid constitutional amendment procedures in the world adopted in 1982 creates a constitutional deadlock in this area. And of course, there's little to expect when we look at the photo on your screen now, of our constitutional founding fathers, and we see that they're all white, all male, and that the landscape in the background is definitely not urban. So you know, when the decision on the slashing of the Toronto City Council came out in summer 2019, I was approached by, you know, it's a process that started in summer 2018, and I was approached by a couple of journalists in an attempt to recommend some comparative work to put that decision in perspective. And at that time, I thought that such comparative work in this field, the constitutional status of cities, did not exist. So I sat down to write that book, and this is City State, and we will spend the next few minutes exploring one of its themes. So let's roll. When we zoom out, so to speak, and look at the general processes or trends that we've seen around the world, we immediately identify extensive urbanization. So on the graph here, you see that the purple line at the top is world population in billions, and the blue line is urban population in billions. And over the last half century, that there has been tremendous growth in both. And we see that the two lines, the purple and the blue, are nearly parallel. Translation, the vast majority of population growth over the last 50 or 70 years has taken place in cities, or at least has been translated into urban agglomeration and urban growth. The projections for the foreseeable future, about 20, 30 years, are really border on dystopian, and we'll see that in a minute. But when we begin to disaggregate the data, we see that urbanization is you know, so there is this serious regional difference when we look at the at this process. And the vast majority of urbanization, urban agglomeration, has taken place in the so-called global south. So I understand this is a charged term, but I'm going to use it throughout the presentation. Predominantly in Asia, which is the green line here, so you can see for yourself, and in Africa, and to a lesser extent in Latin America and the Caribbean, with some urban growth in Europe and North America, but to a far less extent. So that helps put, over the last half century, so that helps put the Canadian debate in context. When we move on and look at the actual numbers, so one of the obvious byproducts of urban agglomeration is the rise of so-called megacities. And there are various definitions to understand the term, but the numbers here speak for themselves. So cities with population over 1 million, a century ago there were 12, now it's about 1,000. And a metro population of over 10 million, we are talking about around 50, 55 now, and projected to be in the vicinity of 90 in less than 10 years. Again, when we talk about numbers that are dystopian, or near dystopian, UN projection for the end of the 21st century suggests that a quarter of the world population will be concentrated in the world's 100 largest cities, and with cities such as Lagos, Kinshasa, Dar es Salaam, Mumbai, Karachi will have anywhere between 50 and up to 85 or even 90 million people. So that's the context. What do we know about constitutional law and its role in perhaps addressing this major challenge? So the human sciences, from geography to economics to political science to sociology, have paid tremendous attention to this global trend of urbanization, urban agglomeration, rise of megacities, etc. In constitutional law, perhaps the most fundamental legal tool we have to govern our political institutions, that there has been very little attention to the city and to urban agglomeration, indeed to spatial governance more generally, beyond the rather beaten path of federalism, the nation state, subnational units, etc. So here we have, three important textbooks in comparative constitutional law, and I'm as guilty as all other scholars in this, because I'm a contributor to two of those books. And altogether, we have here on the screen a total of 130 chapters stretched over 2,500 pages, without a single chapter on the constitutional status of cities, home to, as we just saw, the majority of the world's population. So I guess we could, in the spirit of Italo Calvino, the great Italian author, we could say that we talk about invisible cities here. What I'm going to do then in the next few minutes is to explore with you several of the constitutional attempts or scenarios of constitutional innovation in this area that again go beyond the obvious comparator to Canada, which is the US. So there are some comparative works that compare the status of cities in Canada to the US, and those comparisons are very valuable, of course. But generally speaking, the status of cities in the US is not dramatically different from that in Canada from a broad perspective. And the same thing goes for Australia and for the majority of European countries. So the first scenario that draws a different path is what we might want to call the top-down Asian tigers model. So this is a model of urban emancipation and empowerment that is not concerned at all with any bottom-up democratization process, and is concerned predominantly with economic growth, centrally dominated. There are a number of examples of that scenario. The two most obvious are China, and the Constitution of China designates 4 major cities as centrally administrated municipalities. And the Constitution of South Korea of 1988 creates a first tier of constitutionally entrenched entities directly below the central government. It comprises of 8 major cities and 8 provinces. And the idea is that the mayors of these constitutionally protected cities are represented at the top executive level of those countries. So obviously it's an interesting model for those of us interested in economic growth. It's less applicable to Canada, and the emphasis here is not on empowering city dwellers. It's fostering economic growth and regional development. A second model that perhaps is more relevant to the situation in Canada is what I call here bottom-up national constitutional renewal. And here we have 3 very interesting illustrations. I don't have the time to go into details, but the Constitution of Brazil, 1988, is the first national constitution, a modern national constitution, to constitutionalize the so-called right to the city, formulated for the first time famously by Henri Lefebvre in the late 60s. It's an interesting concept, a little abstract from a constitutional standpoint. And in the Constitution of Brazil, it was the first time an attempt to realize or materialize or make more concrete Lefebvre's right to the city. So that's a really breakthrough in comparative constitutional law governing cities, and the effect has been pretty significant. We'll talk about it later. Another attempt that in that group of tries is India, that in the early 90s adopted 2 new amendments in an attempt to protect local government. Amendment 73 refers to smaller towns and villages, and Amendment 74 grants some autonomy to Indian cities. This has not been nearly as successful as the Brazilian example, predominantly because the Constitution failed to transfer power from state governments and leaders to city leaders. We can explore this later. By far the most successful attempt of these 3 in this mode is the South African Constitution, the post-apartheid Constitution. It includes, in a direct reversal of apartheid-related urban policy, entire chapter in the Constitution, 14 constitutional articles to be clear, that provide full city autonomy and control over land use, planning, social housing, and other such progressive agenda items. It has been proven critical in addressing urban inequalities in during apartheid, pre-constitutional revolution, apartheid South Africa. One obvious example, of course, we don't have the time, I could go on and on. One obvious example is the South African Constitutional Court landmark ruling concerning the city of Johannesburg, planning and land use, social housing, and zoning functions. And in that decision, released in 2010, the Constitutional Court of South Africa confirmed that South African cities have full autonomy over these functions. And that has proven critical in the ability of the city of Johannesburg to engage in progressive redistributive matrix concerning social housing. And Johannesburg is the recipient of numerous international awards on sustainable housing, etc. A third model that we might want to consider is the single city constitutional emancipation model. And the clearest illustration of that model from a comparative perspective is the constitutional transformation of Mexico City. This is a huge city, the 2nd largest in the Americas, after Sao Paulo. And in a process that took 4 years between 2013 and 2017, Mexico City moved from being a federal territory controlled by the federal government, federal district controlled by the federal government, to being an autonomous state in the Mexican Confederation. And it involved a one of its kind, really unique, largest experiment to date in constitution making via moderated crowdsourcing, resulted so the people of Mexico City came together. Of course, there are some reservations on how truly democratic the process was, but it really was much more democratic than any other comparable processes of constitution making, resulting in a dramatically progressive CDMX, a Ciudad de Mexico constitution, including constitutionalization of the right to have an abortion, same-sex marriage, etc. So this is a third mode. And the impact that mode was not tried for the first time in Mexico City. The first attempt in that direction took place actually in Buenos Aires in Argentina in '94. And so we have more span of time here to measure its impact. And in Buenos Aires, the transformation of Buenos Aires from a federally controlled city to an independent province or state within the Argentine Confederation allowed the city to become one of the most progressive jurisdictions in Latin America in terms of environmental protection. Again, it's tremendous. Those of you who are interested, it's a tremendous illustration of how city emancipation in that context contributes to environmental protection policies adopted by municipalities. A fourth scenario that has some bearing upon constitutional status moves away from constitutional reform per se and talks about self-emancipation attempts by cities, and some of our audience have done some interesting work in that direction. Generally, this is referred to as human rights cities. So this is a scenario where progressive mayors and progressive cities commit their cities to international treaties and agreements protecting various dimensions of human rights. The first city in North America that did that was San Francisco, that in 1998 adopted the provisions of CEDAW, and of course a number of other US cities followed suit. From a comparative perspective, two interesting examples are Gwangju in South Korea, which has a really significant history of freedom fighting in the South Korean context. We can go into details if you're interested in the Q&A, a fascinating story. And Tokyo, that much like Mexico City, has some autonomy, and it has transformed practically the Japanese scene in the context of same-sex relations. Again, we don't have the time to go into details, but one prefecture of Tokyo, Shibuya district of Shibuya, started issuing proof of partnership in that context. And within 5 years, the majority of Japanese cities followed suit. We have our humble example here in that scenario of course, the Montreal Charter of Rights and Responsibilities that many of you know about. A fifth scenario, and I hope to cover maybe 7, a fifth scenario of addressing city status through constitutional vocabulary and reform is invoking existing constitutional principles that may be applicable to the city situation through strategic litigation. And some authors or some participants in this conference have written about this in the Canadian context. In a comparative context, this has taken place or has been realized, invoking concepts such as subsidiarity that many of us know about, and subsidiarity is fully codified in the European Union Treaty, either in its Maastricht version or Lisbon version. In German basic law, subsidiarity is not per se protected by the Canadian Constitution, although the Supreme Court of Canada has referred to that principle a couple of times. Margin of appreciation, essentially deference to local authorities, has been used or invoked in this context to defer to local traditions. And the concept of community standards that has been used or invoked or deployed in the context of freedom of expression, particularly, may well be invoked in the context of cities, and we'll get back to this later. Most recently, we have an example of strategic deployment of such a concept of proportionality. The city of Paris wanted to regulate Airbnb and its equivalents. Of course, the argument was that Airbnb pushes the housing market up in a disproportional way, and that in the name of protecting affordable housing, the city of Paris has the right to regulate. And it was aided by some French laws that require authorization for a change of use from residential premises to the provision of short-term accommodation. And the European Court of Justice, the apex court of the European Union, accepted the Paris claim, and its tremendous mayor, Anne Hidalgo, that some of you have some of you have written about, and accepted the claim and supported the right of the city of Paris to regulate Airbnb. A sixth scenario takes us away from constitutional emancipation of city and city functions per se, and moves in the direction of electoral reform. So one of the major issues is, of course, relative underrepresentation of cities qua order of government, but also of city dwellers qua individual voters. And this has been a major issue in a number of countries, including in Canada. And here we have two dimensions to it. One is what I call, constitutionally entrenched electoral malapportionment, one person, half a vote, if you want to call it that way. We are familiar with the situation in Canada and the disparity and the electoral writings in terms of how many voters are there. So those of us who think that this is a situation unique to Canada, well, it's really prevalent and widespread. And here we have two examples, India and Brazil. We won't go into details, but the city of Mumbai, practically 25 to 30% of the state of Maharashtra in terms of population, is only represented by 6 out of Maharashtra's 48 MPs in the national parliament. So essentially half its real effect. And in Brazil, it's even more radical, where votes for Senate we had a panel on Brazil earlier in the conference, so some of you who attended know that, but those who, the residents of Sao Paulo are tremendously underrepresented in that context. So that's constitutionally entrenched malapportionment. But, and this is a book that I think conference attendees should read in addition to, humbly suggest my own book, is a book by Jonathan Roden, my friend from graduate school, who's now a professor at Stanford, who in 2019 published a major book suggesting that in first past the post electoral systems, there is this, including of course in Canada, there is this inherent tendency for urban vote to get diluted. And as a result, for urban interests to be underrepresented, relatively speaking. So the world of electoral reform offers really a wide array of alternatives for in terms of constitutional design, a move to PR, a rural-urban proportional, the so-called RUP that has been put to a referendum in BC and rejected. There are also very interesting models of joint mixed urban-rural districts, MMP models in Germany, New Zealand, Korea, and elsewhere. And another interesting idea in that context is the split cantons model deployed in Switzerland between Basel city and the Basel countryside, so to speak. So in our context, that, for example, would mean not increasing the number of votes or seats Ontario is entitled to, but rather somehow differentiating between Toronto and the rest of the province so that the two parts are equally represented without imposing the vision of one part on the other. We can talk about that later. And of course, there are interesting ideas comparatively of non-territorial federalism and reserved quotas, all of which may be applicable to enhancing urban representation so that we live up to the ideal of one person, one vote. A seventh idea that I want to put on the table that has been tried in some comparative context is fiscal federalism and equalization, or the unit question. So what is the constituent unit of the modern polity? And here we can illustrate this through our equalization matrix here in Canada. So we see Ontario in the middle that has roughly, near the bar, not a major recipient, not a major giver. When all of this is based on an interprovincial matrix of inequality. But when we zoom in on within province differences, we see that socioeconomic differences within provinces far exceed the socioeconomic differences among provinces. And if we even continue to zoom in into cities and metro regions, we see that inequality within metro regions exceeds even that of intra-provincial inequalities. So there is certainly room, and some countries have done this, there's certainly room for rethinking the ideal of fiscal federalism and equalization based on the unit question, so that if we adhere to the principle of equalization, we might very well abandon or at least complement the idea of interprovincial redistribution and perhaps add intra-provincial and intra-city redistribution mechanisms. I have here at the bottom of the slide some comparative numbers that I'm happy to get back to later, should our time permit. But the major point here is that metro areas are far more unequal than interprovincial inequalities. And related to that, thinking creatively about cities or urban areas and rural areas as constituent units, so replacing the existing spatial matrix with perhaps a new one, or at least complementing the existing matrix with a new one. We can think about the concept that sociologists refer to as super diversity. The idea that one of the major differences between cities and rural areas is not just the density and not just numbers, but also super diversity, the intersection of various axis of diversity. And of course, the numbers here are obvious. Cities tend to be far more diverse than urban areas. And here we can cycle back. Of course, Toronto is the most diverse city in the world by that measurement, and Vancouver, not here on the screen, is the third. When we cycle back to the idea of community standards, we can, and margin of appreciation, we can certainly begin to contemplate the idea of, in our minds, complementing the notion of constituent units drawn in the 19th century to something that is more flexible depending on the particular issue we talk about. Let me conclude by suggesting, based on those seven scenarios, and of course there are more. We heard earlier in the conference about attempts to revise things in Italy and in other contexts I'm happy to address. There's only that much we can do in the allotted time. Let me conclude with a couple of slides perhaps with some take-home messages from this wide area of options. First is what I call northern stagnation, southern innovation. As we saw, by far the greater part of urban agglomeration has taken place in the so-called global south, and constitutional innovation in this context comes from countries such as Brazil, South Africa, Mexico, South Korea, Kenya, and which we haven't had the time to talk about, and other global south settings. So from a comparative constitutional law standpoint, this is unique and very important because it is often assumed in canonical constitutional thought that the migration of constitutional ideas is from the global north to the global south. But, and we often forget this when we are embroiled in the Canadian debate, that much of the innovative thinking in constitutional design in this context actually emanates from the global south. The second take-home message is that constitutions matter, and the evidence on this is far-reaching. If nothing else, constitutional frameworks and structures matter as they shape the so-called bargaining in the shadow of the law. And so they change and affect the incentive structures and the fallback rules, so to speak, the null hypothesis under which key actors bargain and negotiate. So what has been termed rather neutrally, intergovernmental affairs and cooperative federalism is not as neutral, of course, when the constitutional background suggests two orders of government that are there and one order of government de facto that does not exist de jure. And we can return to that point later. Of course, acting to any other core value like equality or freedom of expression, nobody argues that entrenching the value of equality is going to solve all the problems. But so it's definitely not a sufficient condition, but it may well be a necessary first step. A third take-home message is that, we may worry about constitutional design as we wish, but ultimately everything is political, and without political will, change is unlikely. So virtually all successful attempts to empower cities point in one direction. We need political support, and that could be both bottom-up and top-down, and conferences such as this one are absolutely essential in enhancing public awareness to the issue. And without mass social mobilization and bottom-up pressure and a genuine sense of democratic renewal and meaningful participation at the local level, not much is likely to happen. And the Constitution of South Africa or Brazil are clear examples of how transformation in the status of cities was created through a major constitutional overhaul by the people. To conclude in more broader terms, urban agglomeration is among the most burning policy challenges of the 21st century. The current figures are absolutely mind-boggling, and everything is set to gain even greater prominence as ever-expanding urbanization processes, mostly in the Global South, march on. In the face of such unequivocal evidence from across the scientific spectrum, the silence of constitutional theory and of constitutional thought, and let me suggest here that the first speaker, this is really brilliant, Zach Taylor, opened the conference by saying that in this conference, we would be hearing from, lots of legal scholars and some realists. So I've been in the Canadian legal academia and North American legal academia for about a quarter of a century, and I can tell you that I can count on, with one, maybe 5 fingers, no more, the number of constitutional scholars who have devoted their lifetime scholarship to this issue. So there are many, many, many more people in geography and urban planning and political science and sociology and economics thinking about these issues than scholars of public law and constitutional design. As a matter of fact, it does not exist in constitutional design. And I would think that given how challenging urban agglomeration has been and will continue to be in the foreseeable future, the silence of constitutional thought and constitutional theory with respect to the mounting urban challenge is striking. And I will leave you with the claim that new thinking about constitutionalism and urbanization and the spatial dimension of constitutional governance more generally is the call of the hour. Thank you.
Great. What a tour de force, taking us around the world with 7 different models on constitutional matters. Thank you so much. That was a great presentation. I do see some questions coming in, but let me start by asking one myself. You said in one of your summary slides that constitutions matter. And I wanted you to maybe talk a little bit about the impact of constitutions for cities. You mentioned Zach Taylor, and I'm going to mention him too, because I guess on the first day he talked about legal empowerment being important for cities, immunity from provincial and federal intervention, and fiscal capacity. Those were the 3 elements he talked about. I wonder if you could, from some of the examples you have from around the world, talk about the impact on those 3 factors. And I'm, of course, particularly interested in fiscal autonomy. Does having original powers in the Constitution actually let you raise the money you need to raise to deliver services?
Thank you, Enid. So obviously, when you're in the proverbial room, who am I to talk about fiscal capacity? I mean, you are by far the leading authority in this country and elsewhere on these issues. So
we're talking about constitutions, and that's you.
You're right. So let me just. I think that's a key question, and it ultimately boils down to the tension in that characterizes this conversation between institutions and societal factors. So this is a debate that has been going on in political science and the social sciences pretty much forever. How are we to change behavioral patterns via institutional change, or via incentives and so on, or via bottom-up societal pressures and so on? What really matters here? And in that respect, constitutional change, and I think that's the most basic element here. Constitutional change has critical symbolic dimension to it. So boiling it down to the nitty-gritty of what exactly it does is very important, and I'll address this in a minute. But ultimately, constitutional change has critical symbolic dimension to it. It signals, the values we are committed to as a community and as a polity. It also offers an entire, it also alters or affects the entire incentive structure of key stakeholders in how they approach the bargaining table, so to speak. And I addressed this earlier in the talk. So it transforms the so-called fallback rules, the institutional or contractual framework that around the negotiations. And specifically to your point, legal empowerment, or to Zach Taylor's point, legal empowerment is, of course, absolutely critical. And as I suggested, based on the South African example, which I think is the best, it's not ideal, but it's the best, it's not perfect, but it's the best model currently on offer from comparative perspective to look at on what may be done in a set of values that really resembles the set of values that we here in Canada believe in terms of multiculturalism, diversity, accommodation, and so on. So the legal empowerment of cities, the constitutional transformation has been dramatic in its impact, and cities have been really able to advance progressive agendas in terms of housing, redistribution, public transit, education, fighting poverty, and so on. Fiscal capacity has not been nearly as effective. And you know that, has been some improvement, but the idea is that constitutions as a meta law or mega law haven't been very effective in transforming the fiscal capacity matrix, and we ought to complement. We definitely cannot think that constitutional recognition of city status is going to resolve the fiscal shortages, and we ought to either go into details when we go to constitutional renewal and who can tax whom and things like that, or we need to negotiate this at the political level that is not constitutional under the shadow, sort of in the shadow of a new constitutional matrix that is going to transform this. And in terms of immunity from intervention, that's right pretty close to legal empowerment. So I would say constitutional recognition or emancipation of cities, and indeed of rural areas as well, it's not necessarily just cities, has definitely changed legal empowerment and intervention from other orders of government, and less so the fiscal capacity element. Thank you.
Well, I think that's true, and constitutions are different. You and I have talked about South Africa and Brazil, both of which have very interesting, relatively new constitutions. And in Brazil, following the military regime, which really liked regional metropolitan governments, the constitution said you can't amalgamate any municipalities without their permission. You get to South Africa and they have a municipal demarcation board, which is appointed by the national government, that sets the boundaries, does amalgamations, and imposes all this. I mean, this is an issue that's interesting in Canada, right? Because we opposed the Metro Toronto amalgamation and we got it anyway. So constitutions don't have all the answers. I think that's fair to say. We've got a lot of comments here and questions. Many of them are on the fiscal issue, but I'm going to leave them because I think you've addressed them. And I'm just going to say that a lot of people said excellent presentation and wonderful things, and I'm going to leave all that out and ask you this question. Do you think the innovation that we see in constitutional design regarding cities in the global south relates to the relatively new constitution building processes in that area compared to most classical processes in the global north? You're nodding yes. So if so, what are the obstacles and hurdles explaining the low pace of constitutional reform in the global north for borrowing constitutional design for cities from the south?
Yes, so this is a great question, and it focuses on the dynamics of constitutional amendment. One of the conference organizers, my good friend and former student, Richard Albert, has written a really authoritative treatise on comparative constitutional amendment, the book published with Oxford, I believe in 2019. And Richard points to I think he has a very, very strong argument there, points to this often, I'll connect this to the question in a minute, to the often overlooked significance of amending procedures in national constitutions for keeping constitutions relevant, timely, and effective. And so it's often perceived as a sort of technical part of the Constitution, but ultimately it determines the efficacy of constitutional arrangements much more than many other more idealist provisions of constitutions. And in our context, and going back to the question, many, if not all, those constitutions of the so-called global south that I refer to are much newer and include more flexible constitutional amendment procedures than the US Constitution, the Australian Constitution, the Canadian Constitution, and many European constitutions. So definitely the fact that we've seen innovation in this context emanating predominantly from the global south has a lot to do with the fact that these constitutions are newer. But it's not just the fact that amending procedures are more, so to speak, lenient in those countries. It is also that the constitution itself was adopted in, say, in Brazil in '88 or in South Africa in '96. And so obviously, urban agglomeration is more of an issue in the 80s, 90s of the 20th century than it was an issue in 1867. So it's not just the amending formula, it's just the entire, just like I assume, and this, I think we can show this relatively easily, that new constitutions adopted over the last 10, 15 years take the environmental climate change challenge more seriously than constitutions adopted in the 19th century for obvious reasons. So one of the reasons why all of this is emanating from the global south is because most global north constitutions are simply old. I don't want to say dated, but old, and are very difficult to change. So this combination creates, if not a deadlock, at least it's very difficult to address not just cities or the urban challenge, but other new challenges such as climate change. So much must emanate from other avenues. So the main, to conclude, on this, the main challenge of constitutions of the global north is, in that respect, is a rigid amending formula in most cases, but also that they are old. And if I may add, perhaps half a sentence, those of us who study constitutional migration of constitutional ideas and borrowing of constitutional concepts will know that the Supreme Court of Canada, or never mind the US Supreme Court or the UK Supreme Court or the German Constitutional Court seldom cite decisions from what we would call the Global South. And there is a bit of India and South Africa there, but almost never Brazil, and almost never Mexico, and almost never South Korea. So there is this, I don't want to say sense of elitism here, but there is this sense among those jurists of belonging to an exclusive club, and we do not look at those countries. So it's a bit of that as well, but that's in the background. Thanks.
Lots more questions. I wonder, I was going to ask you about differences in federal versus unitary countries in terms of constitutions, but Kristen Good has sort of asked a specific question in that context. Do you have any observations to make about constitutional recognition of municipalities in subnational constitutions around the world?
Yes. So I don't know, observations may be too big, but is definitely, we have examples, and Mexico is a good example to look at. Of course, most scholarship on Mexico is in Spanish, never mind the court decisions and constitutional documents and so on. But Mexico provides a very interesting example of some recognition of municipal and city autonomy issues at the provincial level. And I mean, shout out to Kristen Good, who wrote a very interesting paper a couple of years ago, I believe Enid published under the auspices of the series you added, on how this may be implemented or thought about in the Canadian context, in the context of provincial either constitutions or constitutional standards at the provincial level. So definitely Mexico is a place to look at, but there are other perhaps negative. Nigeria is another example. I don't want to go into details, but in Nigeria and in Kenya, Enid, you and I talked about Kenya in an earlier conversation about the devolution process there, and different provinces have different treatment of urban centers in a way that makes the Kenyan constitution fascinating for Kristen's question. But a word of caution. Of all the examples and scenarios that I addressed in this brief talk, India is perhaps the most disappointing. So it promised a lot with those 73rd and 74th amendments. If you read the amendments, they look fantastic on paper, but in practice, it never bothered altering the political control of heads of state governments and state leaders over the definition of what qualifies as a major metropolitan area or major city. So even though even state constitutions in India have some leeway on this issue, ultimately, as long as we have practically an Ontario situation here, where the premier calls the shots, there's very little the Constitution can do other than a declarative level. But of course, Kristen and I will follow up one-on-one with
You'll take this offline.
Exactly, all sorts of other examples. But thanks, that's a great question.
A question from Natalie DeRosier. Part of this conference was also about possibilities within the Canadian Constitution, its living tree method.
Yes.
Any suggestions in that regard?
Absolutely. That's a terrific question. And Natalie has written about this, of course, a number of times. So in my scenario, I believe it was the 5th scenario, I can't recall now, of invoking existing constitutional principles that do not refer directly to the urban situation or the city context, but more broadly to constitutional theory. The living tree is, of course, a major concept that we in Canada, in the Supreme Court of Canada, adhere to all along. So there's definitely room for advancing, in addition to subsidiarity and community standards and margin of appreciation and proportionality. In particular in Canada, the idea of living tree, the evolving nature of the Canadian Constitution. And this is something that the Supreme Court of Canada endorsed many, many times. I should also note, and this is important, media has this tendency to say the court ruled this, the court ruled that. But if we look at the final decision of the Ontario Court of Appeal on the on the city council slashing from summer 2019, it was a 3-2 decision. And Natalie and I had this conversation before. If we look at the dissenting opinion of the two judges there, we see that they refer to living tree head on. So that's their argument, that a constitution adopted when Toronto had less than 50,000 people, and Vancouver was just a small village of 300 people, how relevant it is to governing a nation where 85% of its population is concentrated in cities and 55% in just 6 urban centers. So the living tree is absolutely key here. But of course, much will have to be formulated in this particular concept. But I think there's lots to be done with the living tree concept in this particular area, and I haven't seen too much of it yet. But we'll have to entrust this in Natalie's very capable hands.
Indeed. I have a question from Mariana Valverde about Mexico City, and she was hoping you could say more about the Constitution of the City of Mexico. She's read a critique that says it's just a text and it doesn't have any practical consequences. And I'm kind of interested in it because it is a city-state. And again, we have city-states in Tokyo and some cities in Germany. And the whole concept of city-state is also very interesting to me, which Mexico has now become.
Yes.
We've got about 3 minutes left.
Oh, well, that's
and I have one more question to finish with. So,
look, of course, there are debates within Mexico how progressive, or I should say, how truly bottom-up the whole process has been. And of course, scholars of law and society, of course, Mariana is a prominent one, probably as prominent as these things get in Canada and elsewhere. Has written a lot about soft law and law on the ground. So we can debate. I think that relates to a much broader question that I tried to address earlier. Of course, the idea is not that constitutional entrenchment of city status, much like equality or freedom of expression or any other constitutional value, is going to resolve all problems once and for all. The idea is that it changes the matrix under which soft law unfolds, so to speak. And even in or within the Mexican constitutional community, and I had this conversation with 2 Mexican Supreme Court judges earlier this year, some say that it has been dramatic and transformative, and some say that it has been, that ultimately it has failed to address matters of poverty, homelessness, and things of that nature. So the jury is still out, so to speak. I would think that all said and done, the process of denizens, I don't want to call them citizens, but denizens of Mexico City come together to address via some sort of process what are the values. And if you read the Constitution of Mexico City, the state constitution, it's radically progressive. It's one of the most progressive constitutions on earth. It talks about redistribution and this and that. So to say it's just the paper, look, you can say that the Charter of Rights and Freedoms is just a paper. I don't think it's just a paper. I think it has had some effect. Of course, it's an empirical question and a question of approach to what extent.
So I see they're advertising the next session, but let me ask you one more question to finish off. At the end of your IMFG paper, which I read again today, you say that there are no political incentives to empower cities constitutionally in the global north. So what do you say to an audience like this who's working diligently on constitutional change for cities?
I say that here too, that constitutional innovation was not falling from the sky in Brazil, and was not falling from the sky in Mexico and in Mexico City, and was not falling from the sky in Argentina or any other places we talked about. And so ultimately, it all begins with citizen awareness and with the academia and science coming together, and with the legal profession coming together. And these changes are not going to happen if we do not engage in this question and remind politicians that this is a matter we care about. So nothing will happen unless Canadians begin to think that they care about this issue and this issue matters. Of course, I don't want to take a cynical view here, but it is in the strong interest of the national government and of the federal government and the provincial government not to make us think that way. But that takes us to, you know, in the political theory, a critical political thought direction, to what extent the basic notion of constituent unit in the modern world must continue to adhere to a Westphalian notion of the nation state, or a post-Westphalian notion of, you know, transnational community, or alternatively, perhaps develop some notions of solidarity and legitimacy and sovereignty that emanate more from the local than from the national or the supranational. But that's a overly abstract question.
Well, I was hoping for a pep talk at the end, and I got it. So just thank you so much, Ran. That was such a, you know, you can see from the comments, so much information. I know we're going to want to get those slides and your book. And just all I can say is thank you. That was terrific. And thank you to everybody in the audience for your great questions.
Thank you very much, Enid. And this was great. I enjoyed it. Thanks for the conference. And I look forward to the concluding panel in 20 some minutes.
See you there. Bye.